Good afternoon, everyone. My name is Rob Kitchenoff. I am the president of COSAL. Welcome to Has the COVID pandemic changed the way we should think about antitrust law? For those of you who don't know what COSAL is, it was established in 1986 to promote and support the enactment, preservation, and enforcement of a strong body of antitrust law in the United States. It is the only organization in the US dedicated to lobbying for strong antitrust laws and effective private enforcement. I want to thank Russ Consulting and Kinsella Media for hosting this event today. And I want to also thank Mark Suter from Berger and Montague. This was Mark's idea, putting together this event and this panel. These are his contacts, and it's an amazing thing that Mark has done. This is what we hope is the first in a number of events for our members. And at this point, I would say take it away, Mark.
Hi, Rob. Thanks so much. It's my great pleasure today to introduce our esteemed group of panelists. Sanjukta Paul is an assistant professor of law at Wayne State Law School and a fellow of the Thurman Arnold Project at Yale. Following a judicial clerkship on the Ninth Circuit Court of Appeals, Sanjukta worked as a public interest attorney in Los Angeles, focusing on labor and civil rights issues, and then a research and teaching fellow at UCLA School of Law. Her current work lies at the intersection of antitrust and labor regulation. She teaches in these areas as well as employment law and corporations. Our second panelist is Marshall Steinbaum. Marshall is an assistant professor of economics at the University of Utah, a senior fellow in higher education finance at the Jane Family Institute, and a former research economist at the Roosevelt Institute and the Washington Center for Equitable Growth. Marshall's research and teaching focuses on antitrust and competition policy, market power and inequality, the poor functioning of labor markets, and student debt and higher education policy. Our third panelist is Sandeep Vaheesan. Sandeep is legal director at the Open Markets Institute. He previously served as a regulations counsel at the Consumer Financial Protection Bureau, where he helped develop and draft the first comprehensive federal rule on payday, vehicle title, and high-cost installment loans. Sandeep has published articles and essays on a variety of topics in antitrust law, including the relationship between antitrust and workers and the political content of antitrust. And moderating today's conversation today will be Hal Singer. Hal is a managing director at EconOne, a senior fellow at the George Washington Institute of Public Policy, and adjunct professor at the Georgetown University McDonough School of Business. He has researched, published, and testified on competition-related issues in a wide variety of industries, and has extensive experience in providing expert economic and policy advice to regulatory agencies as well as before congressional committees. And with that, take it away, panelists.
Hi, good afternoon, everyone, and thanks so much for joining. I'm so excited to moderate this amazing panel and give a preview of what a Joe Biden antitrust division might look like. Sorry, that was from Marshall. I want to encourage audience questions and live tweeting with the hashtag #PandemicAntitrust. Given the nature of the meeting, we've decided to take questions via direct messages, or DMs, as the kids like to say. So please DM me a note via the Zoom messaging feature, and I'll read the question aloud, assuming it is good and we have time. For balance on the panel, we tried to invite an antitrust skeptic, but alas, Larry Summers was booked. I kid, but seriously, Joe, don't. Now let's dive in. We'll just start off with a general question, a broad theme about whether the pandemic changes anything about how we should understand the competitive landscape in the United States. Have any power imbalances, for example, between worker and employer, between a dominant firm and its suppliers, or even between delivery apps and restaurants? Have those power imbalances been exacerbated? Are markets now more susceptible to being monopolized or monopsonized? Sandeep, why don't you kick us off?
Sure. So thanks so much, Hal, for inviting me to participate in this panel. I'd like to focus on three themes in antitrust and competition policy that are highlighted by the COVID-19 pandemic. And I think all three call for a fundamental rethinking of antitrust policy in the United States. So the first deals with why is the United States struggling to respond to this crisis? Obviously, part of it is political leadership, and specifically the White House we have right now. But I think antitrust has contributed to the challenges the United States has faced in addressing and containing this pandemic. So a mainstay of antitrust philosophy has been that mergers are generally desirable, they lead to productive efficiencies, they eliminate redundancies. And this has been very attractive for financial investors and executives at corporations. When they buy out a rival or merge with a rival, they can eliminate these redundancies, shed workers, and then boost their stock price, and oftentimes boost their own compensation as CEOs and other C-suite types. So in ordinary times, this is harmful to workers, great for the executives and shareholders, not so great for the workers. And I think this crisis is showing that, these redundancies are actually sort of an important cushion in our economic and social systems. They provide us with a buffer when we face a shock like COVID-19. And so two good examples are, the loss of hospital capacity since the 1970s. We've lost 600,000 hospital beds since 1975, even as the population of the United States is probably close to doubled.
Wow.
And this is very attractive for the financial investors, but left us woefully unprepared to handle a pandemic and a surge in the need for healthcare and hospital capacity. So I think that's one important theme. I think the second is, the crisis has really compounded and deepened the power of tech platforms. Amazon, delivery apps, they were already incredibly powerful, and the crisis has allowed them to sort of capture even more market share and more power. Amazon's eating into the share of brick and mortar retailers that are shuttered by the crisis or facing a loss of customers because people are understandably wary of going to the grocery store to the same extent they did before the crisis. Similarly, restaurants can't have dine-in anymore, so they have to survive using DoorDash, Grubhub, Postmates. And these entities are really using their power to squeeze restaurants that are, even at the best of times, a precarious and thinly capitalized business. They're eating into the tiny margin that they have and preventing them from using alternative options, including direct delivery. There's a great antitrust suit pending against these companies right now over their most favored nation clauses that prevent restaurants from offering better terms to customers who order delivery directly from them. So the power of the platforms is greater than ever. And third, I think we're ripe for another merger wave. We have millions of distressed small and medium-sized businesses, many of which will fail. And understandably, many of them will see larger companies that are secure and cash flush as being white knights. And so unless there is real legislative action, I worry that we'll have another merger wave and have a post-crisis economy that's even more concentrated than what we already had. And sort of a related note I want to make is the Federal Reserve, by injecting liquidity into the system, could actually fuel M&A as large corporations and private equity funds have an advantageous access to this new finance. So, an important part of the rescue package could actually mean greater concentration following the acute phase of the crisis.
Very nice.
So I think all three of these themes call for a fundamental rethinking of antitrust, but I'll leave it there.
No, that's great. That's great. Sorry to talk over you. Sanjukta or Marshall, you want to weigh in? Markets more or less susceptible to being monopolized now in light of the pandemic?
Yeah, I mean, I totally agree with everything Sandeep just said. I guess one thing that I thought was interesting to bring up was there was a panel at the American Economic Association's annual conference in January 2019, so a year and a couple months ago, on this sort of rising issue of market power and whether it was a macroeconomic problem. So that panel included a bunch of economists who've had senior positions in administrations and generally high profile in the field of industrial organization. And their commentary essentially rejected the idea that there's a macroeconomic problem with market power. It took the view and characterized it as consensus among industrial organization scholars that it's impossible to characterize market power in such a macroeconomic way that it can happen industry by industry or market by market. And so to illustrate that fact, the panelists, well, one in particular, but that was agreed to by the rest of the panel, said, if you look at our economy right now, you can see big market power problems in healthcare and the health supply chain. But if you look at retail and wholesale, that looks really good. That's an antitrust success story. And what was meant by that was there's been a ton of consolidation, but that consolidation has made the economy more efficient, enabled the provision of large number of low-cost items to consumers. And so we should view that as a desirable end of antitrust. And I think that mindset is or the weaknesses in that mindset come to the fore when you think about the shortages, the lack of redundancy that Sandeep was referring to, that this is not something that happened by chance or that is just a casualty of a pandemic, but rather something that our policy has designed and been inviting and seen as a positive good. And I think that suggests that in light of circumstances, we rethink the overall policy aims.
Very helpful. Sanjukta, you want to weigh in?
Yeah, and super briefly, because I think that the problems and the way in which the pandemic has exacerbated existing problems has been very well laid out already. I think that then the question becomes, should antitrust policy counteract these tendencies, which were already there, both sort of in the economy and the economic policy that shapes the economy more generally, but specifically in antitrust, or should it further exacerbate them? And there's clearly two views about that. And I think I think we're going to be discussing all of this more, but just to sort of tee it up. So specifically, should the only goal of antitrust law be to promote consumer welfare? What should the role of economics be? And specifically, I think we should be very clear, not just economics, but a particular paradigm in economics that interacts with law, right? So really law and economics. What is the role of efficiency? And if we start to find that these concepts are not sufficient actually to provide the conceptual grounding of antitrust, our antitrust thinking, then what replaces it? What is the affirmative purpose of antitrust? I would suggest that it includes what I would call dispersing economic coordination rights, not just promoting competition, which is important but is a secondary goal actually, but dispersing the right to engage in economic coordination, in the economy at large. And I think obviously there are other tools besides antitrust that do that as well. So I'm sure we're going to talk about that more. But also, I think importantly, just to put another kind of theme on the table, is when we do talk about competition, are we just talking about promoting competition per se? Because we're actually never doing that. All of these other things actually, like consumer welfare and efficiency, ultimately function as checks on promoting competition. I'm sure that the lawyers here are, very aware of how that functions in day-to-day practice, and it also does so I think in the scholarship that then justifies how the current paradigm. So if we don't, if we decide that these are not sort of that the rule isn't we allow and require competition except where there are productive efficiencies from mergers or from vertical restraints or something else, or where there's countervailing consumer benefits of a very specific kind. If we decide that's not sufficient, or even the primary type of limit on competition that antitrust should be promoting, then what are the limits on competition, or what are those other values that antitrust law should be permitting? And I think that ultimately there's a concept of fair competition that lies at the heart of this area of law and motivated it, and that we have to get back to that and consciously defining what fair competition actually means. I think we're going to talk about some cases that highlight that.
Yeah. That's very helpful. And I know you all recently filed comments with the House Subcommittee on Antitrust. And in particular, you're asked to answer this question about whether antitrust, at least as it's currently understood by US judges, was up to the task of dealing with the unique challenges presented by dominant platforms, particularly in the tech space, the tech platforms, the tech giants. I was wondering if each of you we could go around quickly and you could just tell the audience what your top line recommendation was in your submission and why you think it's so important to fix that problem. Sanjukta, why don't you go first since you're there?
Sure. my primary recommendation, and I should say, I think we filed separate comments, but I certainly endorse many of the others that were filed. So I don't think this is necessarily the most important thing. I think it's a piece that wasn't covered in some of the others. So the one that my comment focused on is actually, perhaps sounds paradoxical, but I'll try to justify it. My recommendation was to actually expand coordination rights. So actually the one place where I think we should lessen antitrust enforcement, which is unfortunately the main place it focuses right now, which is on horizontal coordination beyond firm boundaries, which is, I think, something that disproportionately hurts and hurt smaller and less powerful actors, including but not limited to workers beyond the bounds of employment, such as independent contractors, but also small business. Also, many of those smaller restaurants that Sandeep mentioned in their interactions with the meal delivery platforms, franchisees, others, which then also indirectly hurts workers again. Not only does it hurt those players, but it helps the dominant players, because I guess maybe you want me to stop and we can talk more about this.
But I mean, one concrete
Okay.
example, right, would be allowing the publishers to coordinate in their
Yeah.
dealings with someone like Facebook, right?
Right, and some would object that those aren't sort of classic small players, or not all of them are, but many of them are. But that brings up the point that it's not just about small and big, it's also about the power differential. So the newspaper publishers, when they're going up against Google and Facebook, I absolutely think should have coordination rights. And I think that is, we're also seeing how important local journalism is in the context of this pandemic. And unfortunately, the dominant platform's power has further suppressed journalism, the revenues that publishers can then pass on as wages.
Nice. Marshall, do you want to weigh in? What did you tell them to do?
Sure. So I view my suggestions and commentary as entirely complementary with Sanjukta's, as she suggested. I focused on vertical restraints, and the platform business model is being premised on the laxification, as I call it, of antitrust law vis-a-vis vertical restraints across the boundary of the firm. So I have written in some of my prior scholarship, and again in that brief, about antitrust in a previous era that looked askance at vertical restraints used to discipline a large number of smaller actors vis-a-vis a dominant actor. And that jurisprudence was very clear that in saying that if you're not an employee, you can't be told what to do by a dominant player. I mean, there's some restrictions on that, but that is basically the thrust of the jurisprudence. And that jurisprudence was totally abandoned by the Chicago School. In fact, you could see that as being its main target, is the exercise of control or domination across the boundary of the firm by a powerful dominant firm against a large number of independent, smaller, or putatively independent smaller firms. So I found in the course of writing that piece, I found a quote from Easterbrook that I hadn't focused on before, though I'd read that article, in which he basically says, just as an employer tells their employee what to do, and that's efficient because it takes place within the firm. This is is given a sort of cozy notion of where the firm boundary lies. So a dominant franchisor in this context telling a franchisee what to do is also efficient. And I think the reality in the law is, or at least the idea in the law ought to be, that if the boundary of the firm exists, then antitrust is the sphere that governs or that regulates the exercise of power across that boundary and limits what powerful dominant companies can do to their dependent fleet of independent or putatively independent actors. So I feel like that is inherent in the platform business model. I think we've touched already on the ways in which it's exacerbated by the pandemic, restaurants vis-a-vis the delivery platforms. I focused on ride sharing in a lot of my work, and those platforms are active in the sort of delivery space as well. And I think the Facebook publisher dynamic also pertains to that. And basically what I recommended to the subcommittee was that they totally reverse the antitrust jurisprudence of laxifying vertical restraints. So for firms that are dominant, they should be prohibited from engaging in all manner of restraints that are pretty much baked into the ways that the platforms operate. So things like setting the prices of supposedly independent transactions. They claim they're offering a neutral platform, but in many of the cases, the platforms actually set the price, or at the very least use most favored nations clauses to try to govern what the prices are, even if they don't directly set them. They allocate individual workers or service providers, independent, if in this context, to individual customers. They use pay policies here. I'm thinking specifically of ride sharing, but I'm sure it applies elsewhere as well. It's called in the economics lingo non-linear or bonus-based pay, where basically it's saying, you should work in this geographic area, you should work at this particular time, and in particular, you should work a given percentage of your time on the shift on our platform versus the others, that have the effect of restraining competition. They're analogous to exclusive territories and other types of vertical restraints that antitrust is well used to dealing with. So all of those things, I list a few more in the document, that if you can show that a given firm is dominant, and I have a whole sort of series of potential criteria for establishing dominant that go beyond, that include concentration in an antitrust market, but go well beyond that. If a firm is dominant, then they can't do this list of things, which I think are pretty much inherent in the platform business model.
And Marshall, that would come about through legislation.
Yeah, I mean, at this point, I think the jurisprudence is such that that's essentially the only route. I mean, I guess you could imagine a world where the federal judiciary suddenly decides to understand how economies work, as opposed to taking the Chicago schools' advice about that. I don't think that's likely. So I have definitely proposed that as legislation for Congress to take up.
Very helpful. And Sandeep, what was your top line recommendation?
Yeah, so OMI in its submission really tried to cover the waterfront. And I think our big theme was we should think about anti-monopoly, not antitrust. Antitrust is just one tool in the anti-monopoly toolbox. Apologies for the lame metaphor. And we really need to think about contesting both concentration of power within the firm among financial constituents and executives, and then also concentration within discrete markets. And our vision is one of reallocating power, not blindly promoting competition. So very much in line with Sanjukta's idea of dispersing coordination rights in the economy. I think there are sort of three, there's a three-legged stool: conduct, structure, and cooperation. So on the conduct side, I think we should directly limit the power of the platforms through things like common carriage rules, which establish a presumption in favor of non-discrimination and openness to all comers. So think of the Amazon marketplace and restricting Amazon's power to decide who participates on the platform and on what terms, or depriving the company of that discretion. Similarly, affirming and instituting rules of fair competition. So things like restrictions on predatory pricing, tying, and exclusionary contracts, sort of reviving the mid-20th century post-war approach to monopolization and unfair competition. And on item 2, structure, this structural reforms and dissolution can take two forms. I think both are important. First is sort of the breakup of vertically integrated conglomerate firms, force Amazon to restrict itself to certain businesses, sort of directly tackle the conglomerate nature of the company as it presently exists. And then also a horizontal aspect. Why do we need a single dominant e-commerce platform? Are the efficiencies of scale really that great that we as a society would lose much if we had 6 or even a dozen competing e-commerce platforms? I think it's also worth considering that often what is presented as efficiency is simply the exercise of power against upstream participants, whether they're workers, suppliers, or sellers. And the third leg of the stool is cooperation, what Sanjukta talked about, sort of giving coordination rights, the right to freely associate to workers, small firms, and other dependent parties, some of which are medium-sized firms themselves who are radically disadvantaged and disempowered vis-a-vis the large platforms. So I think we need to consider all three. We should reject this sort of false dichotomy or trichotomy that's advanced by certain actors, that it's either breakup or conduct, or countervailing power or breakup. We really need all three. And I think we can actually achieve a lot using existing authorities, including good precedents and things like Section 5 of the FTC Act. I don't think that gets us all the way there. We do need legislation on discrete issues, but we shouldn't assume that present law and present statute is categorically bad and beyond redemption.
Got it. All right. Well, let's get back to some pandemic-specific themes. There's a push, I know you are aware, by the White House and the Senate Leader Mitch McConnell to absolve employers of any liability for COVID-related lawsuits that brought by their employees. This move is arguably part of a larger effort by conservatives to limit legal rights and class action in particular for workers. For example, the Supreme Court has upheld binding arbitration clauses in contracts with workers that deny them their legal rights. So in light of all this, what's the import of private enforcement in the wake of the pandemic, particularly given an absent and sometimes anti-worker antitrust division of the DOJ? Marshall, you want to go first?
Oh, well, I am not relatively underexperienced in the realm of private litigation compared to my colleagues as well as you. Yeah, I think the idea that waiving the right to sue is, somehow good for the economy has been totally disproven by this, especially in the environment that you mentioned, where there's basically no public enforcement. And as anybody who's participated in private actions is aware, in many cases, it's the victims who are best positioned to understand where they have been harmed. I think the case of a pandemic is especially questionable to waive all legal all liability, because of course the whole nature of the pandemic is that it can be passed from person to person. So just this sort of blanket waiver of liability is very far-reaching in terms of the victims of the pandemic and the source of their ultimate harm. So I mean, as you say, it's of a piece with existing I guess legislation and political movement. I guess one thing I could say about that is there's this idea, again, kind of coming from the realm. I mean, I guess this is the other piece of what Coase is well known for, the idea that individual negotiation is somehow more efficient at bargaining to efficient outcomes than regulation or public legislation. That kind of Coase theorem type result is really premised on an economy in which there are no imbalances of power. So, insofar as it is a mathematical result, it's a mathematical result that hinges on the assumption that there's essentially equal partners in the bargaining relationship. And so this is, that very stylized setting, obviously not relevant, to say the least, in the antitrust framework, is then kind of taken to be like, oh, well, this private arbitration is somehow like the instantiation of Coasean bargaining, whereas litigation is the intervention of the state or something, and therefore inefficient. And that's just a fantasy.
Other panelists, you guys want to weigh in on this one, on the waiver, the intelligence or lack thereof of the waiver of liability for workers? Of firms, so as to incentivize them to get us working again?
Sure, I'll take it. So, I think private enforcement of laws, antitrust, consumer protection, labor and employment laws are always extremely important. We should think of private enforcement as sort of the direct enforcement of law by all of us in our capacity as consumers, workers, small business owners. And, even if we had an ideal public enforcement system, which we certainly don't, I think private enforcement would be a necessary supplement, because good claims are bound to slip through the cracks or be treated as a secondary or tertiary priority by federal and state enforcers. So even in an ideal world, we need robust private rights of action. And we don't live in the ideal world. We have a government that is strongly beholden to corporate interests, is not interested, in fact, is quite hostile to the rights of ordinary people as workers and consumers. So private enforcement is especially critical now. And the idea that, private rights of action need to be further limited is just the latest sort of audacious attempt of the tort reform movement. It's already extraordinarily hard to bring meritorious consumer and worker suits. The Supreme Court has erected numerous obstacles against private litigation. You know, the sort of almost categorical enforcement of mandatory arbitration, class action waivers, extremely high requirements for class certification, extremely easy motion to dismiss and other pleading standards. So that there's really no basis in fact that liability should be limited. We, if anything, need much stronger private rights of action and should view the attempts of Mitch McConnell and other Republicans as almost driving the final nail in the coffin of private rights of action. This is a 40-year campaign to gut the plaintiff's bar and our right to vindicate our rights through private lawsuits. And I think it's worth emphasizing that this whole story has been based on myth. There's never been any evidence of vexatious lawsuits, the notion that lawsuits are deterring, pro-competitive conduct or other socially beneficial behavior. It's based in myth, and we should be pushing strongly and resisting the latest attempt to further restrict private rights of action.
And Sanjukta, did you want to weigh in on this one?
I would just add, I would just add to that, you mentioned arbitration clauses at the beginning. I mean, I feel like I'm probably preaching to the choir here. But it goes way beyond arbitration clauses, right? I mean, as any plaintiff's lawyer knows, there are, sorry, there's some chat popping up.
Well, go ahead with this one. We'll get to the chat.
Okay. So, right. I mean, there has, in addition to the things that are sort of more apparent, like the public tort reform movement, and this being just one iteration of that, arbitration clauses. There's just also been a gradual shift in class cert standards and, frankly, summary judgment standards across areas of law, I think. I mean, as a former plaintiff's lawyer, I certainly anecdotally think this is the case, where the idea that you've just got all these, frivolous lawsuits everywhere, it's ridiculous. It doesn't make any economic sense for plaintiff's lawyers to be doing that. And so I think we have lots of checks in place, specifically, I guess, with respect to I understand the point that, if you're in a really unusual situation like the pandemic, that should there be some special change to either tort or contract law. But I don't see the argument for that here. Maybe it would be useful if we had somebody promoting this view so we have something to grapple with. But Hal, maybe you need to give us like the best version of. Well,
I think their argument goes something like, if you don't limit the liability of these firms, they're going to be afraid to open, and we're never going to get the economy going again. But one thing that's.
But they should be. But so first of all, that's ridiculous, because you should be taking into account the actual risk now under pandemic conditions. It's different from like force majeure contract, clauses and contracts. I think a little bit different here. I understand more why we would make potentially exceptions to contract law. I don't want to open that, but that's fundamentally different from saying that we should make an exception effectively to tort. I mean, I don't just mean torts here, but I mean all public law torts too, like antitrust and labor and all of those. So that in that realm, that we should somehow be making it so that businesses aren't pricing the actual risk, which they're already not when it comes to workers, frankly, and workers' families. That's being underpriced in their decision making. The idea that we need to cause them to underprice it more is absurd. And I think here it's important to think about this from a broader, sort of the broader set of alternative policy tools that are available. I know you're going to ask this potentially later on, but not just in the sense of sort of sort of things we can do with respect to private market actors other than antitrust, but also in the sense of responses to the pandemic, because there's no pressure to reopen if we're actually doing the social provisioning we need to do for ordinary people to be able to make rent or just suspend rent so that you don't have to make it, and then suspend mortgage payments so that and are able to put food on the table. There's nothing in terms of the real resources we currently have physically as a society that prevents us from doing that. There's no need to reopen meatpacking plants in order to do that.
And don't we also, I realize I'm just the moderator here, but just to weigh in one other point, I mean, we want to incentivize the employers to make investments in precautions that protect the workers, right? So it seems to me that we get these very perverse outcomes that you haul your workers back and then you expose them to these same risky conditions without having to make any investments in their safety. It just seems like something that hasn't been well thought through. There's a question that's pending from the audience. Let me just go ahead and put it now. It goes to Sanjukta, but I know Marshall wants to weigh in here too. And the question says, if improved horizontal coordination could help workers seeking relief from monopolistic abuses, maybe that was monopsonistic, how could non-employee independent contractors in the gig economy, such as Uber drivers, coordinate and organize? Or to put it another way, would your coordination rights extend to gig workers as well? And how would it work
Oh,
just
yeah.
as a matter of practice?
Absolutely. No, and I mean, in fact, that was sort of like the original motivation for the thought, but I think it's very important for it not to be limited to gig workers for a whole bunch of reasons. But absolutely, I mean, and I think maybe anticipating, because I think you're going to maybe ask about labor law as well, or maybe we should just get to that now, I don't know. But I don't think we should just look to labor law for a solution to this problem. So it's absolutely true that we need to step up efforts to both to enforce existing labor and employment law so that workers who are being misclassified are actually, getting the coordination rights that they would get under labor law. But secondly, I don't think we can just outsource that to labor law, partly because frankly, the big tech platforms have mounted massive campaigns to prevent that from happening, right? So we see that in the campaign against AB5, which there's been a breakthrough in recently in California with the state AG and local city attorneys actually filing for injunctive relief for reclassification, which is huge. It's really an unprecedented step in terms of ameliorating this on the labor side. That just happened last week, I think. But we can't, so both because of the political opposition to that, because of the tendency to game the boundaries of the edge of the labor exemption to antitrust and the edge of the employee category in labor law, both of those, we can't limit the expansion of coordination rights. So that, as the other examples that we've already talked about show, the need for countervailing coordination rights goes beyond just the labor law problem or the sort of labor problem. And I think that if we change that aspect of antitrust law, we remove much of the incentive to misclassify in the first place, actually, because I think that's a major reason to do so. We've seen that, just really briefly, just because this hasn't come up, we've seen Uber itself do this, sort of both sort of, as Marshall was saying before, Uber exerts, massive restraints, including literally setting the prices of its, of the putatively independent businesses who are the drivers on its platform. It's probably the most extreme in this way, right? At the same time, it, we think Uber was involved in some way. The United States Chamber of Commerce brought an antitrust preemption lawsuit against the city of Seattle a few years ago when it sought to create a local collective bargaining mechanism under basically under Parker immunity, the state action exemption to federal antitrust, to provide collective bargaining outside of labor and employment law for Uber drivers. And the response to that from the platforms basically was to bring an antitrust preemption lawsuit. So they're using antitrust as a sword against the coordination rights of the much smaller, weaker players that are drivers, while, as Marshall was saying, exerting these vertical restraints over drivers in a way that mid-century antitrust law probably wouldn't have permitted. And both of these are contrary to the original intent of antitrust law, which we haven't really talked about.
Marshall, you wanted to weigh in? Besides mentioning that the DOJ and the FTC weighed in against the workers in that suit, right?
Yes, they did. A bipartisan decision by the FTC that was left over from the Obama administration. They were unanimous in condemning worker organization. What I wanted to mention, in addition to what Sanjukta said, although I'll get back to the labor law issue in a second, is that I've been a strong supporter of the lawsuit started as Meyer v. Kalanick, then became Meyer v. Uber. That is definitely in this vein, even though it has some crucial divergences from this idea of independent contractor organizing per workers. So this is a lawsuit that was in the Second Circuit at the district court level in New York State, eventually got sent to arbitration because of the mandatory arbitration clause. So that was a bad decision in its own right. The essential thrust of the case was that Uber and all of its drivers are engaged in a horizontal conspiracy basically to fix prices, especially the claim was directed at surge pricing, and the plaintiff in that case was a consumer. The fundamental point of the case was really motivated on the labor side, however, was a response to at that point, the failure of the misclassification lawsuits to achieve the reclassification of Uber drivers as employees. And the idea was, okay, if they're independent businesses, why does Uber get to set the prices? And in the context of that case, in order to achieve the sort of most favorable disposition to the plaintiffs, the claim was that this was a horizontal conspiracy between Uber and the drivers. So I think that's the piece of that that's suboptimal to have to allege a horizontal conspiracy. I mean, they have the Apple eBooks case to draw on in terms of favorable case law there. But the real problem is a vertical problem, as we've been talking about. And so I can see why a plaintiff's strategy would involve alleging the horizontal claim, but I think the policy issue concerns the vertical nature of the price fixing. And I think notwithstanding that the case law would be less favorable, there's still room to bring such a case on behalf of the drivers or similarly situated gig economy workers.
I think just to add to that, I think one reason why there may be room to do that, and I'd be curious to actually hear what the lawyers here think about that, but is that it seems to me that even though vertical restraints law, case law has obviously, become so much more liberalized in the sense of having no teeth, since the 1970s, as Marshall was saying, it's still the case that all of the key precedent that has made that has made antitrust law so permissive toward power that is enforced through vertical contracting beyond firm boundaries, is in the context of the distribution of goods. Pretty much all of those key Supreme Court precedents are. And that is not what the platform business model is at all. There's no real sense in which, so in those cases, those typically involve restraint, price or non-price restraints placed by sellers to downstream actors, and that's just not what's going on with Uber. The drivers aren't buying something that they're reselling to consumers, and that Uber is then putting a restraint on that product. That's not the case. And so I think that while it is difficult, I think that is a distinction that really should be drawn. And
Yeah, so that should definitely be a distinction that's drawn out in the case law. I think we saw with Ohio v. American Express the sort of conversion of these economic models that supposedly show vertical restraints or efficiency enhancing for consumers kind of transmogrify into the idea that anything vertical is good for consumers, and hence a very different business model, namely the platform business model, is somehow sort of blessed with the same light as the vertical restraints in the goods distribution context that Sanjukta was referring to. In terms of independent contract, returning to the broader premise of the question about independent contractors as potential antitrust plaintiffs is how I interpret it. That we have seen that in this UFC case that I know Hal is involved in, which is certainly promising and has has a pretty shocking facts associated with it.
We have to talk about that case a little bit.
Okay. Well, let me let me just say one last thing to finally draw the circle all the way back to Sanjukta's bringing up employment. So in the AB5 context, there's been the allegation that employment status would restrain and reduce the autonomy of independent contractors, and then I guess in return they would get some sort of job security, but that's been posed as a trade-off, and then different independent contractors would fall on that trade-off in different places. I guess that's the claim. And I think that fundamentally misunderstands the use of employment status in the context of independent contractors, because there's one, I think, startling example in the context of all this California jockeying over who's covered by AB5. The franchisors have tried to make franchising exempt from AB5, and then in response to that, at least one set of franchisees, the franchisees for 7-Eleven, said, no, we don't want to be exempt from AB5. And the reason why they said that is because they want to be able to make a claim for employment status under AB5 towards the franchisors. It's not that they actually want to be classified as as employees. It's that they want to use that as a weapon to get the franchisors to back off. And so I think that raises the point that autonomy kind of works together with solidarity, if you want to make that the principle of horizontal coordination, and in the employment, so directed specifically in the AB5 context, that means that people who want to be independent, not employed, can nonetheless use the threat of employment status to be more independent, to gain autonomy. I think that there's a flip side on the antitrust context, which is not just, I mean, I guess this gets back to what Sanjukta and I were talking about before, not just that horizontal coordination enhances the power of workers, but that antitrust on the offensive. So it's not, as Sanjukta said, the Chamber of Commerce wants to use antitrust as a sword to go after worker power. What I'm suggesting here is basically that workers or independent contractors can use antitrust as a sword to reclaim their power, basically.
I think another way how those two things go together is coming back to that idea of antitrust law not just being about promoting competition, and there being then exceptions to that, or exceptions either in the form of consumer welfare and quote unquote efficiency, but also in the form of specific exemptions, but rather thinking about antitrust law as allocating coordination rights, because that's what it does, and then thinking about reallocating those, because currently what it does is it allocates coordination rights to powerful actors. To continue with the model we're talking about, it allocates coordination rights to the dominant platforms. Uber gets to set prices, DoorDash gets to greatly restrain price setting power by independent businesses, etc. And it actively prevents the smaller actors in that same ecosystem from exercising coordination rights, which includes, and I just read the question in the chat, that was actually, I think I maybe misunderstood it a little bit, how can such smaller players coordinate and organize? Well, the same way they do, everywhere else. There's the traditions of organizing, not only in the labor movement, but also in the same small business and small player associationalism in the fair trade movement that was and is part of the antitrust tradition. And that is what Brandeis, who was very involved in the creation of the FTC, and then involved in important antitrust decisions on the Supreme Court, that was part of his vision for antitrust, certainly, right? So there's models of associationalism and organizing to draw from in the labor movement, in sort of the fair trade movement, the cooperative movement, which Sandeep has written about, and in the antitrust tradition itself.
Guys, let me try to get Sandeep back in. I had a question
could I
for
add
you.
a point to that discussion? Yeah, I mean, I think so here's a hypothetical that sort of illustrates the perversity of current antitrust law. So at least thus far, Amazon, this giant concentration of property worth more than $1 trillion has received a clean bill of health from our DOJ and FTC. This huge corporation, no antitrust issues according to DOJ and FTC. At the same time, if its millions of sellers, or even a subset of the sellers, try to band together and seek a lower commission on sales, maybe some protections in process against being delisted, they would be, under current interpretations of antitrust, committing a per se illegal restraint of trade, and could be faced with CIDs from the FTC, possible legal action. So even as Amazon is allowed to build power through consolidated control of property, the small players on its platform can't engage in even limited forms of concerted activity, that's an antitrust violation. So the system is completely upside down right now.
Let me turn, if we can, because we're running a bit short on time, to the question of mergers. And the reason why the question is for you, Sandeep, is because I saw you tweeting about this the other day. But as we all know, there's a recent proposal from Senator Warren and Alexandria Ocasio-Cortez that would impose a merger moratorium on large corporations and private equity firms. And the bill has received some swift pushback from FTC commissioners Noah Phillips and Christine Wilson, who point out that M&A activity is actually falling during the pandemic. So Sandeep, what is your response to this argument?
Yeah, so that's based on a really static snapshot. It's like, let's look at how things are at the depths of the crisis and sort of generalize from there. I think that's a mistake because this is not going to last indefinitely. We will at some point emerge from this crisis and recover. And if you look at our current situation, we have the perfect recipe for large-scale M&A activity, millions of distressed small and medium-sized businesses, a handful of large and very large businesses and private equity funds that are secure and flush with cash and ready to go on a buying spree. So let's step back for a moment and actually have a sense of how this is going to evolve instead of saying, well, we had fewer merger filings in the first week of May in 2020 than we did in the first week of May in 2019. There is no problem. That's really simple-minded and simplistic. Second, see this false dichotomy. It's like we either have large-scale merger activity or millions of businesses will go under, millions of people will lose their jobs. There's another way out. The federal government is providing extraordinary support right now and should actually ensure that the support gets into the hands of small businesses and their workers instead of being hoovered up by the very largest. So the false dichotomy is false. We're seeing it rejected in real time as the Federal Reserve and Congress are allocating billions, if not trillions of dollars to aid businesses and workers. We've also seen this argument that the DOJ and FTC are such great enforcers, let's count on them to do their jobs. This might be the most comical claim of all, because even if you accept that consumer welfare is the only objective of antitrust, the agencies have been a miserable failure for the past 40 years. There's an abundance of evidence that they're failing to protect consumer welfare. Look at the work of John Quokka. So even if consumer welfare is the objective, they should deserve a letter grade no higher than a D-. And if you sort of step beyond that and believe that anti-merger law is about preventing the concentration of economic and political power, their failure is only more acute. So we really need to use this crisis to rethink our approach to merger policy. Mergers generally don't create productive efficiencies. They often lead to higher prices, and importantly, they concentrate economic and political power. And there's really not much evidence supporting the status quo. So I saw Noah Phillips posted a critique of the merger moratorium a couple of days ago and made this claim that mergers are generally beneficial, only a small fraction of mergers are harmful. And he had a footnote which I thought would provide some evidence or at least examples for his support and for his claim. And there's really nothing there. He just points to earlier assertions by scholars and enforcers saying, well, mergers are generally good. It's like, come on, after 40 years, you should be able to point to at least a half dozen examples of mergers benefiting the public. And he still can't do that. So I think when people like Phillips and Wilson attack the merger moratorium, they're really speaking as keepers of the Chicago school fate. They're not open to revising their views. Even if we presented them with 200 studies showing that mergers are harmful, they'll come back and say, well, I have methodological quibbles with these studies. And until you give me 210 studies, I'm not willing to revise my assumptions and priors about how the world works. So, I think their critiques are off base, unsupported, and reflective of a status quo that's increasingly discredited and facing political and policy pressure.
Can I just add one thing? I noticed that in at least one of the Noah Phillips interviews where he was articulating this position, he also specifically relied on this general appeal to jobs, that somehow there will be, that mergers will save jobs of companies that are otherwise, so not only
like the T-Mobile Sprint merger saved jobs. Go ahead.
Yeah, so right. So obviously generally mergers don't save jobs. It's also, even in the context of pandemic, totally speculative in all the ways Sandeep was saying. But also, again, it's really, really important to think about the alternatives here. You know, that we have the capacity to engage in direct public employment. We should be thinking about that instead of thinking about propping up, you know, companies that serve as the ability of sort of financial speculators to leech off of the public. I mean, why is that the only way to provide jobs in a pandemic? We really have to think about those alternatives. And I want to add one more point, which is that on this theme of the pandemic, and Sandeep was saying it's an opportunity to rethink, I think it should be an opportunity to rethink the whole allocation of coordination rights under antitrust law, and specifically because we are funneling so much public investment into private firms at this time, right? So I'm not against bailouts. I think that it's important. You know, Marshall may have some quarrel with this, and think we should do it all through unemployment or something. I actually think it's important to keep the current sort of mechanisms of production that we have going to some extent, but it should help us see that this entire infrastructure of corporate America is publicly supported. It already is sort of through, that's the point of coordination rights, that you're getting coordination rights that other people are not getting. It's not just sort of, that's the point, that you're getting that from the public. There has to be a social contract, and now you're also getting public funds. Well, the other side of that social contract should be to finally reallocate who gets a voice and who gets a benefit from these firms.
Marshall, go ahead.
Yeah, sorry, I have to leave unexpectedly early. I'm sorry to break off here, especially since I'm sure we could discuss what Sanjukta just said at great length, but thank you very much for having me.
Yeah, go ahead. Hope everything is okay.
Yeah.
Let me just see if I can squeeze in one more. I see that we're about 4 minutes from the top of the hour. And I want to talk about my favorite platform monopolist of it, Amazon. I know we've touched it briefly, but I think that the pandemic has pretty clearly weakened brick and mortar retailers and therefore increasing Amazon's grip over retail even further. And we see this flexing of this new muscle that Amazon has in many, many ways. You know, they're forcing new customers to join waiting lists for Amazon Fresh and Whole Foods Market Delivery. And then they flex their muscles with respect to suppliers differently by punishing them in search results if the supplier doesn't keep excess inventory for Amazon. But as we all know, the antitrust laws, at least with respect to Section 2 monopolization, requires one to connect up a particular restraint with this flex or this exercise of market power. And just the mere flexing by itself is not necessarily a violation of the law. And the question that I have, I guess, for you guys is, is the standard that we use right now up to the task of policing a dominant platform like Amazon, or do we need to consider embracing a different standard, perhaps something along the lines of what the Europeans have in the abuse of dominance standard? Sandeep, Sanjukta, anyone want to take this one?
Yeah, I'll take a first stab at it. So I think one thing I'll say is, the antitrust laws are not frozen in amber, immutable for us to change. They've changed over time. The antitrust laws today are very different than what they were in 1969. And, the Supreme Court itself has reserved itself the authority to interpret and reinterpret the law over time based on economic learning. Obviously this current court is not going to interpret or revise the law in a way that we support, but that flexibility and elasticity is there. So that being said, I'll freely grant that the court has done a lot of damage to the Sherman Act, especially Section 2. It's very difficult to bring a predatory pricing claim under existing standards. It would be actually a fool's errand to bring one under existing standards, as articulated in cases like Brook Group and Matsushita. Similarly, refusals to deal claim are very hard to prosecute. So if Amazon delists one of its sellers, the seller in theory has a refusal to deal claim against Amazon, but it faces very, very long odds successfully winning a case like that, or even surviving motion to dismiss. So I think that's the sort of sad story. I think we should look beyond the Sherman Act. We should look at the Clayton Act and FTC Act and realize that a lot of the good precedents and authorities are still there. The court hasn't actually done much damage to those two areas of law. in part because there haven't been that many cases. So for instance, Section 3 of the Clayton Act actually prohibits exclusive dealing and tying by non-monopolistic firms. Let's use Section 3 again. Let's at least test it. Let's see what the courts are willing to accept in this day and age. Similarly, the FTC Act is very broad, unfair methods of competition. The Supreme Court, as recently as 1986 said that, the FTC functions like a court of equity, has broad interpretive power over unfair methods of competition. Let's call on the Biden administration to appoint good people to the FTC who are actually prepared to test this authority instead of just sitting on it and letting it collect dust. So I think there's a lot that can be done using existing precedents. I still see a need for new legislation, especially around private rights of action. I think the court has made it incredibly hard to bring a private claim. But before we sort of abandon all hope and say that Congress has to act before we can do anything, let's think critically about what authorities we have today and call on our public enforcers to put their tools to good use.
Very good. Well, we're at the top. Sanjukta, if you have something short, I'll let you go. Otherwise, I'll say goodbye. All right. Well, thanks so much for joining. That was great. And it's really nice to get the band back together, especially during these troubling times when we're looking for any kind of kernel of happiness in our lives. And I appreciate COSAL for putting this together. And I don't know, maybe we should do this again sometime.
Thank you for having us.
Absolutely. Yeah, thanks so much. Thanks, Hal. Thanks.
I want to thank everyone, all of our panelists, for a wonderful presentation today. I want to thank again Ken Zylstra and Rust Consulting for being our sponsor today. And again, Mark Suter, the co-chair of our Young Lawyers Division, for putting this excellent panel discussion together. We're looking forward to lots and lots of great things from our Young Lawyers Division under Mark's leadership. Coming up on June 25th, we're going to have the second one of these events, which will feature Diana Moss of the American Antitrust Institute. And we look forward to having you all join us for that. And there will be other events coming up for COSAL that we will be publicizing, and we look forward to those. And with that, I thank you all and wish you a good day.
Have a good weekend.